Is in-house, so she doesn't have a public profile like all the other attorneys. She is general counsel and vice president of corporate affairs for Lackawanna Insurance Group. You've been there about 5 years?
Yes.
And Adrian, before that, was an attorney, a defense attorney. So she knows the ins and outs of workers' compensation. She knows this issue. She's very aware of what's going on in the industry, and I've found her to be an excellent resource. So I'm really glad she could be with us here today to sort of give the insider's perspective. I always tell people what my clients think, but I'm really just saying what I think they think. She can explain how it really is from the insurer side. We also have joining us again Jacqueline and Rob. They double as attorneys sometimes. They're very smart, and they'll correct me when I say dumb stuff that's perhaps not correct. So without delay, I want to stop where we kind of left off. And I say kind of left off because Steve was talking about the petition that he had before Judge Rego, and those of us who do workers' comp might have caught on to the fact that he was talking about a claim petition. Claim petition being what? A denied injury. So he does not, the carrier in his case, the self-insured employer, whoever it might be, doesn't have an open payment responsibility. So he's got a bit of a double hurdle there. He's got to first prove that there's a work-related injury, and in my opinion, then he can get to the second issue, which is whether that's causally related medical treatment. So it's an interesting angle on it. I think the bigger concern for employers and insurers in Pennsylvania right now is, what do you do if you have an open claim? You have a claimant who's treating with opioids or spine cord stimulator or any number of the treatment methodologies that you guys all know about, and they start using medical marijuana. They send you a bill. What do you do with it? And if you don't do anything with it, you get the penalty petition. So I wanted to start there because I think it's probably the first thing we're going to see in litigation. It's going to be a penalty petition. It's going to be somebody seeking payment for medical marijuana under the auspices of the Pennsylvania Workers' Comp Act, not necessarily on the Medical Marijuana Act. So can you be penalized for not paying for medical marijuana? Well, before that, Adrian, do carriers want to pay for medical marijuana?
I haven't been in this situation yet. I think my initial reaction would be no. I don't want to pay for medical marijuana, but I think that's really short-sighted. I mean, spinal cord stimulators, opioids. There are so many forms of treatment that are expensive, and that $70 a month in medical marijuana would be a really good deal. So that makes me think, maybe I would want to pay for it, but I probably wouldn't want to pay for it in every claim. So then I would ask myself, if I want to pick and choose which claims I want to pay medical marijuana on, does that create a bigger problem for me in Lackawanna? Because my claims handling is inconsistent. So, and if no one, I guess now I'm trying to think of how would that be apparent to, the community that Lackawanna is inconsistent in handling medical marijuana. And it could be as simple as, a big claimants firm has a lot of Lackawanna cases, and we've paid for medical marijuana on a couple, we've denied it on others, and they'll raise our inconsistent practices.
Yeah, I've seen that, just to bring my life passions together, and as boring as they are, with compounded pain cream. I've had people raise, well, this carrier paid for pain cream for claimant A, so they sure as heck better pay for claimant B. Mm-hmm. So I could see that happening with medical marijuana. To get to my not legal advice, if I were presented with a penalty petition for medical marijuana, I would initially inform the judge, and Barack is still smarter than me, so he probably knows the actual case citation. There's case law that says in Pennsylvania an employer or carrier can't be penalized for failure to pay for unique, unproven new medical treatment. That doesn't necessarily mean that you can't be subsequently ordered to pay for the treatment after that. It might not be a violation of the act, but the workers' compensation judge, I believe, could still say, yeah, you still have to pay for that treatment just because it's new or different. So I would point that out for the judge, no penalties. But that doesn't mean that the judge can't try to say, don't pay. So the next thing I would go to and it was what Steve was trying to avoid, was the actual language of the Medical Marijuana Act. If we go all the way back to the beginning, and I told you my viewpoint is that the Pennsylvania Medical Marijuana Act sets forth who can actually gain access to medical marijuana. It also sets forth who can actually pay or has to pay for medical marijuana, and it excludes insurance carriers. So that's going to be something that you identify for the judge immediately. The other aspect of the Pennsylvania Medical Marijuana Act, and the specific language should be in your handout, says that you can't be compelled to violate any other laws in adhering to the Medical Marijuana Act. And so I would say to the judge, look, here's the federal law, here's how it's listed as Schedule 1. You're compelling me to violate federal law and pay for medical marijuana. Those would be the defenses I would raise.
And I would also add to it that we all know that the number one thing when we see these penalty petitions is we ask for the bills. Where are the bills? Let me make sure that they were properly submitted to my carrier, and I'll go from there. Where's the bill that you're going to get? It sounds like the dispensaries aren't going to bill anything to you, so it sounds like you're going to get a receipt from a claimant. It's not going to give you the information that you need, and you also, without having that properly submitted bill, you lose your right to file a utilization review. So you lose a protection that you have under the Act. So I don't know that you could be compelled to pay something that you don't have a protection against. Especially with, as the doctor was saying, there are no formal prescriptions from a doctor. What the patient decides to take is decided at the dispensary. It's decided basically by these tax. I don't think that these tax are healthcare providers under the terms of the Act. So I think there are a number of different levels to get away from a penalty or a situation where you do not want to pay.
Well, I think to take that one step farther too is, the other argument would be the payment obligation has never arisen. If they can't satisfy the requirements of the medical documentation with the supporting bill, the HICFA form, you have no obligation as a carrier or a TPA to even pay for the treatment in question. Now, we were speaking before we started about how the reimbursement issue if somebody has already paid for it, but I think that's that's the same argument that you have no documentation to relate this to a work injury, and they're not going to be able to provide it by the sounds of it.
Yeah, and just to walk it back a little bit, I thought conceptually the best way to go through the interaction between the new medical marijuana usage, which is for the most part starting February of this year, and our long-standing obligations on the workers' comp defense, workers' comp insurance side, is to really look at where is this going to bleed into different aspects of the claim. And I think you'll see that it's not just something where it's do we have to pay for it, do we not have to pay for it. That's a big aspect of it, but I think you'll see issues with this at all levels of the claim. And one of them is what Rob had talked about in the earlier session, initial report of an injury. Are you going to defend if somebody is already working for an employer, they're using medical marijuana for another reason? It's not for a work-related injury, it's for one of the 17 and up to 20 listed conditions. They're using it for that, and they suffer a work injury. Do you try to raise an intoxication defense? Do you try to raise issues about the very vague standard of care language that Rob talked about? And we all know how difficult it can be to prove violation of a positive work order, but it's something that you're going to need to investigate with the claimant. Adrian, have employers been asking about this? Is it something that they're concerned about?
Yeah, employers are definitely asking about it, and there's a lot of concern. There's a lot of misinformation. And I think one of my objectives, going back to the office and dealing with our insureds is to educate. And I think that will be helpful. But there's so many unknowns. I mean, I learned so much here today, and I thought I knew, I don't want to say a lot about medical marijuana, but I thought I knew, enough. But I just learned so much. So there are no black and whites. There's, it's very gray. And I think we'll get a lot more direction as the next few months proceed.
Yeah, and I think one of the difficulties is when we met, we had a few meetings with legislators when it was being debated. So back in February, March 2016, just to give some input about, okay, what are the workers' comp carriers going to feel about this? What are their concerns? What are the employer's concerns? Part of that discussion at that time was that, well, and the legislators are saying this, well, why can't you treat it just like opioids? So if you have somebody who's using opioids and they get injured at work, what do you do there? Or if you have somebody who's using opioids after a work injury and they can't go back to their job, what do you do there? Just treat it just like gabapentin. The problem is for a lot of our employers, they can't treat it just like gabapentin because they have OSHA regulations. They work in a facility where they have chemicals that are stored that are governed by federal regulations. So just because somebody using gabapentin could operate the forklift to move the chemicals doesn't mean that somebody using medical marijuana could do that, because why? It's a federal law and it's a Schedule I drug. So what we tried to communicate to the legislators then, and what I've heard often from my clients, is that I don't think there's necessarily a pushback to medical marijuana. I think people are very curious about it, but I think it raises issues for employers in Pennsylvania that really puts them in a tough spot. And that's really what we see at the outset of a claim petition. All right, do I want to, drug testing? Steve said nobody should do drug testing. I can't believe nobody yelled at him in here, but I get that question all the time. What do I do with drug
Maybe
testing?
that's why he's not here. He was scared away.
Yeah. I always make Rob answer that question, but it raises a lot of issues, and it raises a lot of issues for the comp insurance carrier, because that could be a liability that they take on, and it could be. And Adrian, we didn't talk about this, but I could foresee a scenario in which you have a workers' comp carrier who's willing to pay for medical marijuana. They see it as a cheaper treatment methodology, and you have an employer who's really mad about that because they don't want their employees treating with medical marijuana. They don't want somebody like that coming back into the workforce. Mm-hmm. So if we move along, let's say the claim petition is filed.
Well, can I just make one more point? So if an employer, if that scenario arises and an employer does not want that claimant to return to work, even though they are capable of returning to work from a physical standpoint, the employer could say no, and then the insurance carrier would have to, in all likelihood, pay indemnity benefits.
They might have to say no too, depending on the circumstances. If the employee is on.
Right.
Yeah, Rob
might not be able to return to work.
Right.
Yeah.
That was one of the main things we pushed back in 2016, was the concern that you're going to create, and it might be a small population, you're going to create a workforce population that as soon as they have a work injury that they might otherwise be able to return from. Or it could be somebody who's working. They have a work injury and they're on med only, they're not getting any disability benefits. They might be in a work classification for when they start treating with medical marijuana, the employer can't have them working anymore. They file a reinstatement petition, and as a defense attorney, I think they have a pretty good argument. Because why are they out of work? They're out of work because the employer can't allow them to work because of treatment they're getting for the work injury. You might not have to pay for the medical marijuana, but you might have to pay the TTD. So that's something that I haven't seen yet. I haven't seen a reinstatement petition. But
No, but then that also then cuts away from the savings that you would have of potentially having them use medical marijuana as opposed to that spinal cord stimulator. Now, if you're paying a weekly benefit, because as we all know, once they start that weekly benefit, it is harder and harder to get them off, so that you have to weigh which one, the lesser of two evils in that scenario.
Yes. So keep it moving. I know I don't want to go too far past our promised deadline. One thing that when we were talking, Adrian, we kind of disagreed on was whether, if we're before a judge, be it a claim petition or perhaps this reinstatement petition, how hard do you want to push on the claimant's use of medical marijuana? And what I mean, for anybody who's been in a workers' comp courtroom, depending on the judge and depending on the claimant, there's certain questions you can ask, there's certain ways you can ask those questions, and there's certain times when you shouldn't ask the questions at all. From my perspective, I think I would probably ask pretty often. And I'm not trying to paint the claimant, and what I'm talking about is if we have a claimant who suffers a work injury and they've been treating with medical marijuana on an ongoing basis, I'm not trying to make them look like they're Cheech and Chong. What I'm trying to do is explore how that gets me to past medical history. Because as the doctor explained, you have a lot of people that have had long-standing conditions that this is just a new type of treatment that they're exploring. So if it's a new claim petition, they just had a back strain last week, and they're already trying medical marijuana, I want to know what was going on before. How long have you had this back pain? I see it as more of an indicator, and I know, Adrian, you agreed, but you didn't want me to be too mean. And
No, I mean, I just don't know if it would be a standard question.
Yeah.
And I look at it a little differently. I mean, I think it can go to credibility, but only in some pretty limited situations. And I also would question, I mean, I might just ask about pre-existing problems and, you know, get my answers and then try and confirm whether those responses from the claimant were true or not. So if I am going to ask about medical marijuana, I'd want to know if I could confirm that the claimant's answers are true. You know, did they just get the card after the work injury, or did they have the card before? And is there a way for me to access that information, you know, apart from just asking the claimant? So can we look online? I mean, is that information accessible? The state registration? You know, can I subpoena, whether it's the state or, you know, some other entity to confirm that information? Because if I can't prove the claimant's a liar, I'm not really sure I would want to go down that road.
Yeah, and that's something where I think it's very dependent on the scenario, and it's dependent on the judge, and it might be dependent on where you're at, what region of the state you're in. So talk to your attorneys about that and see what their approach might be, because I don't think you're going to find a judge using it to assess credibility, but it can, in my opinion, speak to pre-existing conditions. And I sometimes run into untruthful claimants who don't tell me about stuff, once or twice.
See, I actually disagree. I do think it could go, depending on the judge, it could go to credibility, because some of our judges,
Rob's from a different region, so.
you know, in Central PA, some of the judges have you swear upon that holy Bible that you're telling the truth. And I can think of 2 or 3 judges immediately that would look at this and say, you, and I don't mean this in a bad way, you're a drug user, and that's going to go to my credibility of how I view you and what you're telling me. And there's only 2 or 3, but I do agree that, you know, it's not necessarily for every case, but depending on the judge that I drew on that case, I may very well ask that question.
Yeah, here in Philadelphia, they assume everyone's a drug dealer or user. That it's not going to get you anywhere here in Philadelphia, but maybe out there.
Yeah,
You're more innocent out than the sticks.
All right, so what about when you're going through presentation of medical evidence? You're getting your independent medical examination, or you're cross-examining, in my situation, you're cross-examining the treating doctor. With regard to the IME doctors, it's very dependent, I think, on where you go with whether you want to pay. But Adrian, would you want your IME doctor specifically addressing the use of medical marijuana in an instance where you're not paying for it?
Probably not.
Yeah.
And I would imagine a lot of our IME doctors wouldn't want to touch it with a 10-foot pole if they haven't been certified by the state. They probably, if they're not certified, they probably don't want to deal with it. And they might just refuse. And I don't know that I would, because maybe they're not educated. If they're not certified, maybe they don't know enough to offer an opinion that will ultimately be beneficial to my claim.
I agree 100%. Is there a question?
But wouldn't a pain management specialist be just as qualified? I mean, I don't think having the certification from the state would mean that doctor, if it's to be a medical marijuana doctor, would disqualify a pain management specialist from offering opinion.
I would suggest you don't want to go there. And the
Yeah.
reason, as Adrian said, the reason why I would say that at this point is I do some work with medical malpractice, and as you well know, experts come in all different forms and abilities. And at this point in time, the expertise that you would obtain from 99.9% of clinicians who might sit there is so soft and that I would be very careful with getting a physician involved. I would keep him out of it.
No, I'm suggesting if somebody's asking for it, I don't think you have to have another medical marijuana doctor say, no, it's not good for him.
You would actually be surprised, the list that's available in this region, when we reviewed those names, about 60%, I would say, were either IME doctors or doctors we see treating claimants on a regular basis. So it's gonna pop up fast, and it's gonna go really, really quickly down a certain road because these doctors are already certified. And one of the doctors, I had his deposition, he was my expert. The medical marijuana was not an issue at all. I just said to him, hey doctor, I saw you were on the list. And he said, I love it. Like, I think everyone should take it. I think it's great. I'm not prescribing opioids. I'm prescribing weed. I'm like the happiest doctor in the world. And I just like, I would never want him to be my expert on that issue because that's the opinion I'm going to get, and I'm never going to be able to get a full recovery opinion probably. You know, it's going to be, let's just treat him with weed for now, and
Yeah.
the judges are going to look at it as, well, it's a small cost, so I'm not going to cut off this guy's benefits. That's how I would look at that issue.
And he's a happy doctor.
He's
But
very happy.
Yeah, I think just to even add another misguided viewpoint perhaps, I look at most things, and I try to counsel my clients to look at most things from a cost perspective. So if I'm having a claimant examined by the IME doctor, if it's an accepted injury, I'm trying to either get a full recovery or get him back to work. I'm trying to shut down either the whole claim itself or shut down wage loss. Do I want to then, while I'm doing that, get into a side fight about the justice and the righteousness of medical marijuana when, as we heard from Dr. Nicholson, it might be a couple $100 a month? So if that's what it is that really worth bringing that into the play? Because assuming we're not paying for it and nobody's filed a penalty petition and the claimants decided to pay out of pocket to use medical marijuana, from my perspective, let the claimant do that. You focus on, are they fully recovered, can they work, the traditional things that we're looking at. Because I think once you muddy the waters and you spend half the deposition talking about the growing facility and all this other stuff, and Dr. Nicholson's on the other side, knows exactly what you're talking about, then I think the judge is just going to get confused. So,
I mean, I'm not opposed to medical marijuana, but I think there are so many unknowns that concern me. So I have a card, I can go in and, you know, I can pick a variety of products. I mean, someone might recommend a product, but, you know, you could have the top of the line or some other ones with dramatically different costs. And we don't have a doctor recommending a dosage or a particular product. Maybe a claimant wants the Mac Daddy, you know, product, and maybe I'd be willing to pay for a lower end product. I mean, there's such little control as it relates to medical marijuana, and we do have that control with traditional medical treatment in workers' comp. So you know, it's just so hard to decide how you're going to handle it now when we don't know how this is all going to play out. And another concern I have, so medical marijuana is pretty affordable right now, but is it going to be that affordable in a year? So if I decide as a policy, Lackawanna is going to pay, because we think we'll pay less for medical treatment in the long run. Well, if prices skyrocket a year from now or 2 years from now, maybe it's not that affordable anymore, but I've already set my policy, and I'm going to seem really disingenuous to the workers' comp judges arguing an inconsistency between state and federal law 2 years from now after I've just paid medical marijuana in most of our, in claims that dealt with medical marijuana. So
I'll just make one comment about that. If you look historically across the country, the price will continue to drop.
Oh, it will?
Absolutely. You see that in every state, from California, where 5 years ago the cost for a kilogram was somewhere around $3,000. Now it's below $1,000. And they've just certified to bring 13 more grow facilities on. We know the cost, there's going to be more competition, so the cost will continue to decrease over time.
So who
it's
would
going to be the
setting
first
the
medical
price?
treatment ever to
Yeah.
decreasing.
Absolutely.
Yeah, we're
If you ask
you
me,
know,
I'll
like,
put a spinal cord stimulator in everybody, because I certainly get paid a lot more than I would
Yeah.
for medical marijuana.
so dispensaries set the price. I mean, and it would be,
There are some limits that they can do, if you look at the statutes, the state has the right to come in and say, no, this is well above what would be considered acceptable norms for cost, and they're going to sanction it. But for the most part, it will be dispensaries, but again, there'll be 150 dispensaries, so they themselves will have competition. You can go to any dispensary you want in the state, so I think you're gonna continue to see the costs go down.
Okay. Just finish up on medical evidence. Obviously, the flip side is the treating doctor. So if I'm representing the insurance carrier, I'm cross-examining a treating doctor who's treating the claimant with medical marijuana, whether my client's paying for it or not. Do I want to focus on that during cross-examination? Answering my own question, yes. I like to focus on all kinds of things during cross-examination. What am I going to look at? I'm going to look at the same things that Dr. Nicholson already told us are weaknesses in the system right now. So you mentioned a pain management doctor. They know how to manage pain. Why can't they do the medical marijuana aspect of it? I'm going to highlight the fact that because of the way the statute is set up, they're completely separated from what the claimant actually gets. It's not like gabapentin where you can adjust the dosage and adjust the duration. They're at the mercy, so to speak, of the dispensary. And when you go into the dispensary, I'm going to highlight for the judge the names of the product that is available, because, and I don't know why this is, and I tried to ask it at the dispensary yesterday. They had Kosher Kush, they had
Pineapple Express.
Midnight Relaxation. I think there's a very realistic medical treatment use for medical marijuana. I don't know why you wouldn't call it something that sounds like a medicine.
I can tell you why, because they were required to place the strain on the package, and each one of those, if you go back, you can actually go to leafly.com. It's a great website that talks about, you can get a lot of good data off of leafly.com, but it'll talk about strains and it'll talk about what the concept of a strain is. And essentially, they're required by the state statute to put on there what strain they were actually growing and where that was extracted from. So that's what that's all about.
Okay.
On the subject of Kosher Kush, we learned at the dispensary that the tinctures are both kosher and halal approved.
Oh, there you go. So we'll move on from the medical evidence aspect of the claim. Let's talk briefly about utilization review. If you get a bill, do you want to submit it to utilization review? And Adrian, you know the elephant in the room with regard to utilization review, the formulary.
Mm-hmm.
What is that concern?
Well, medical marijuana is not going to be on the nationally recognized drug formulary if the governor signs the law. So that would start the process. That would be triggered by Senate Bill 936. So a doctor would have to then say it's medically necessary in order to trigger the insurance company's liability for payment of the medical marijuana. But it's so circular because are you going to pay it? If you're going to pay it, you're going to pay it regardless of regardless of if it's on the formulary, because it's cheap. I mean, we just talked about that. But if you want to go down the road of denying it, I think there are better arguments than it's not on the formulary.
Yes.
In fact, there are cleaner arguments than it's not on the formulary, because then you're going to be forced into the UR process if you go down the not on the formulary path.
Yeah, I agree 100%. You would likely spend more to get the utilization review determination than you would spend for the year of supply, number one. I think you have a stronger and cleaner argument just denying the bill under the basis that we discussed earlier, which is that the Medical Marijuana Act says you don't have to pay for it to begin with. And I think if you go before a workers' compensation judge, which is where you'll eventually end up, and you're trying to argue that the medical marijuana is not causally related to the work injury, you've already given that up. So if you're trying to argue that it's not reasonable and necessary, just because it's not something that's contemplated to make you pay doesn't mean it might not be reasonable and necessary. We see that a lot with drugs used for off-label reasons. It might not be something that Medicare is going to pay for, but I bet all of you have been ordered by a comp judge to pay for it for an off-label reason. Pain creams, I've unfortunately seen lots of judges order people to pay for pain creams. So I don't know that you'd have a great shot going before a work comp judge with somebody like Dr. Nicholson explaining the whole process with a claimant saying, yeah, I take this tincture and my pain goes away, and the judge is going to say, no, this is who he signs. I'm not gonna let it go. I think you'd probably have an uphill battle there.
Mhm.
I would keep my arguments in the denial stage. I don't know if you guys agree or disagree.
Absolutely.
I absolutely agree.
Okay. We talked briefly about what if you want to pay for medical marijuana. As many people brought up, they don't have a mechanism in place. I actually asked the CEO at the dispensary, what would you do if an insurance company sent you a check? And he didn't.
He had a look of fear, like
Yeah.
his face was.
And I
like,
said to him, I said, man, if
"Oh."
somebody sends me a check, I'm cashing it. I don't know where you grow up, but so I think it's not something they've even thought about. So you probably can't put them on auto pay. You can't be paying directly to a dispensary, so you'd have to do it as a reimbursement to the claimant. I can't think of anything else.
I think that's the only way, as of right now, absolutely.
Yeah, and what does that lead into? It leads into the same questions that we talked about with settlement.
Mhm.
So it's not going to be something that's considered in a Medicare set aside. You're not going to go to CMS and they're going to say, yeah, why don't 75,000, 30 years of marijuana, you're good to go. That's not going to happen. So it's going to be one of those drugs that we do see that falls outside the auspices of CMS, but the claimant still wants you to pay for, and you might have already been paying for the past 5 years. We see that a lot where the MSA says, here's the amount for all this stuff, and then there's this one other treatment that's not contemplated by the MSA, but you have to pay for under the comp rules. So do we want to set aside money for payment of future medical marijuana, Adrian?
It would just depend on the case.
Yeah, and I think you would probably not call it that.
Yeah.
Yeah.
Because what I'm concerned
You
about...
definitely not put that in your CNR agreement.
Well, and then we should have talked about the sunsetting provisions, and we can now. What I'm concerned about is that the law's going to change. So 3 years from now, people say, it's back to reefer madness. This stuff is terrible, and we need to get it out. We're going to shut it all down. And Pennsylvania takes away the Medical Marijuana Act. We're back to the federal standard, and you have a CNR agreement showing that you gave this guy $50,000 to buy medical marijuana, or to buy marijuana, and now he's on the street trying to buy it, saying that you gave him the money. I can't imagine any prosecutions, but it's not something that I would want my clients putting in writing.
Yeah, I don't see any upside.
Yes, the sunset provisions, it's discussed in the article, I believe. There were provisions in the Medical Marijuana Act that, and I forget the specific wording, but basically if the federal standard changes, this all goes away. So what I mean by this is the state law, which could be a complete mess. I think in the long run it might be better, this is my own opinion, to have a federal standard so that we don't have all these conflicts and all these issues with sending the claimant $50 so he can go buy medical treatment. But there would be a lot of hoops to jump through if the State Medical Marijuana Act went away, immediately. One thing we did talk about was cognitive concerns with regard to if somebody's using medical marijuana, they go to a mediation, they go to a CNR hearing. A lot of our attorneys, a lot of the claimant's attorneys will ask the claimant, are you under the influence of any illegal drugs or anything that would affect your ability to understand what you're doing here today? You probably want to be careful with that question. I view this, and I think we agreed on that, as not all that dissimilar from opioid usage. I've had a few mediations where the judge told me that he or she didn't think the claimant was capable of having a settlement discussion because they were under the influence of opioids. The doctor, I think, explained that the hope is that most of the medical marijuana usage isn't that strong, but it's certainly something that you want to be aware of to an extent. The only other thing I have, and I don't know how many lawyers we have in the room, but, and this circles back to my initial comments, was that there's, and Steve would be able to comment on this strongly, when this industry first started up, there was a lot of concern by lawyers that we're giving people advice about what to do vis-a-vis state law, and we're also telling them to break federal law. And there's been a PA, the ethics committee issued an opinion, an advisory opinion saying, well, you can do that as long as you do certain things. I think it's something for insurance carriers to be aware of, though, because often when I talk to insurance carriers, I tell them, well, you gotta give people information, make sure you have your panel of doctors, make sure you have a good job description, you know, all the good practice things that we talk about. But you have to be careful too, because you don't want to be encouraging someone in writing to be too free and loose with what's still an illegal federal drug.
Mhm.
So, anybody have any questions on the comp side? Or did you have
I
anything
just
to-
had a point to make, and it was after looking at the patient acknowledgement that was circulated around the room. There's some language at the bottom that was in agreement to hold the dispensary harmless and indemnify, blah, blah, blah. That's unusual. If you have a medical provider treating your claimant, there's not that hold harmless indemnification overlay to the treatment. So, I mean, that just made me uncomfortable, and it's an issue that, you know, I'll definitely watch, because if something bad happens and there's some, you know, liability or culpability with the dispensary, that patient acknowledgement could eliminate the potential cause of action and impact the insurance carrier.
Okay. Anybody else? Any questions? Anybody ready to go buy some medical marijuana for their
We
injured
have the
workers?
pamphlets of the dispensary up
Yeah.
here, if anyone
Yeah.
would want one.
And you guys, you should have our contact information, so if you have any follow-up questions, feel free to call, email, anything like that. You're welcome to take the writing with you. I want to thank all the people that came, Dr. Nicholson, Adrian, Steve, and I want to thank you people for coming, because I think it was a fun presentation. Thanks a lot.